Nyanum Ghana for Muina Aquaba the Bankasa TV. And I know first time I'll share Kasa TV. I'm sure say, but like no subscribe, no share, send everything beyond. When your fresh news updates, I should know who they are Ekoso or Ghana. There is a lot of tension and a confusion at Ekoso. Our Supreme Court are in Assembly between the Speaker of Parliament, Alban Badgin, and the Chief Justice in Assembly concerning a bill beer some weeks ago. Alban Badgin passed concerning the Human Rights, Sexuality, and Family Bill. As a bill, I didn't send simply about my name. The Attorney General Godfred or Democrat Chimusa Sabiono, Sasanko passes Sabino, the song of the executive in him, the president of the country, and another Danko Fadu in him, and Snowbill who come Faso, and Sana, or passes Sabion, Nelson Sana, Agban Kingsford Wabinier. They see attention confusion at Elcoso Supreme Court in Ramgana for Muina, Monkamunenko Jessa, and Simultrum Mumbra, Madame Muinas.
Until if it is a law, it is assented to by the president, judiciary has no jurisdiction to try to pry into it. This is notice. We have to take this seriously, or else our legislative authority is being taken away from us by other agencies and arms of government that should be resisted by this house, or else your being here is of no consequence. The law is very clear on this, and so until a bill is assented to by the president, nobody has any business to take that process that is being considered by the house to the court. And I don't want to preempt the judgment of the Supreme Court in this matter. But I'm giving notice because on daily basis, I'm being served with writs as a party on matters that are being considered by the House. That's why I'm compelled to say this.
The question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories, from First Republic to Fourth Republic, we have had a private members bill such as this.
Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former...
In the
very last Parliament.
In the very last Parliament.
Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members bill, and it was the first private members bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the time. I think it was not a very controversial subject matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the First Finance made assist the court in that regard. The first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. And especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern because the basis for the Speaker to exercise or the person presiding to make a determination did not arise because it was from the executive. But that is why I consider this point so important that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president's status. So that's quite different. My preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made whichever way, then the nation can move on.
Determine which question? Determine the question in the substantive suit, or determine the question in this application?
No, determine the questions in the substantive suit.
The substantive
Yes.
suit.
So pending that, then there ought to be a preservation of the status quo for the court to be given opportunity of determining. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have with all respect demonstrated before you, the collective good actually will be in respect of holding a status quo for the court to indeed determine whether the bill that is being sought to be, for want of better expression, rushed is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament. Indeed, all the processes in Parliament have been completed. Parliament effectively has concluded the processes. And indeed, now, if what is supposed to be transmitted to the President will actually be titled an act, it is just left to the signature of the President and then to become law. And I would say that, having regard to the completion of the processes in Parliament, what Parliament has done will constitute an act under Article 2, Clause 1, Paragraph B of the Constitution.
So your presentation or your submission is that the jurisdiction of this court has been properly invoked?
Yes, as
for this application or for the substantive action?
Pardon me?
For this application or for the substantive action?
Oh, I'm only saying so because of the requirement in injunctions to show the existence of prima facie case as well as a substantial important question of law.
I think, can you clarify that point? I think I missed it. You are saying that Parliament has completed its processes, its procedures, and that what they are seeking to do is an act that's beyond its proceedings.
No, my lord. But I'm saying that now we can actually find an act having been committed, and the act has been committed. In fact, two acts. First is the opinion of the person presiding, which in itself will constitute an act. The determination by the person presiding will constitute an act by the person, not an act of Parliament.
To help all of us, I think that I want to read 2(1)(a). A person who alleges that any act or omission of any person is inconsistent with. This is what you mean. Attorney General?
Yes, Mr.
Any act or omission.
Yes, Mr.
And your submission is that there is an act.
As in an action by a person, yes.
And there are two acts actually.
Yes.
This is your submission.
Yes, Mr.
The first act is the determination by the person presiding. And the second act is the completion of the proceedings.
Processes in Parliament. Respectfully, that's so. So I pray to rest my submissions, except as the court may have some questions. The court has no questions. May I rest?
Please, let it be known that when it comes to lawmaking,